Justice Sikri, Dr. Vinod Sethi, Dr. Mathu, eminent senior counsel, distinguished guests, the awardees for their nominees, ladies and gentlemen. A very good morning to all of you. A couple of months back, I received a call from Justice Patnaik that we have to come and attend this program. Justice Patnaik and I, we go a long way back. He was a judge in my parent High Court, Guwahati High Court from 1994 to 2002. When he went there, I was a very raw junior, hardly 3 years into my practice. But when he left in 2002, I think I had established myself as a lawyer of some standing at that point of time. My father had also appeared in a large number of cases of the Advocate General before the bench of Chief Justice B.K. Khanna and Justice A.K. Patnaik in the first court. So when Justice Patnaik made the request, I immediately agreed to participate in today's program. But more importantly, for me, it's a great honor to the organizers, the Capital Foundation, for inviting me to be a part of this celebration. Friends, while I was a judge in the Bombay High Court, the COVID pandemic broke out. And initially we were all confined to our homes. The courts were also closed for a short span of time before opening virtually. At that point of time, one student ambassador, she said she represented SCC Online and she sought for an online interaction with me. Normally, I am of the view that judges should not give interviews, not to speak of holding press conferences. But since this is law related, SCC Online is law related, I said yes, please, we can have an interaction. And during the course of the conversation, a question was put to me by her as to whether there was any political or executive pressure on the judiciary. I said, I have never faced any such interference. No. But I also remember to have said that our judiciary has been built literally, brick by great men and women over a long period of time. Its foundations are strong. There may be aberrations here and there, but judiciary has the inherent resilience to protect its independence, which is non-negotiable. Today, we celebrate the legacy of one such great man. Vaidyanathapuram Ramakrishna Iyer lived for almost 100 years. His life spanned across a whole spectrum, from a fiery political activist during his younger days, as a minister in the Namboodirpad government in Kerala, a public-spirited lawyer, and then as one of India's most erudite and welfareist judges, who continued his public engagement post-retirement into the final years of his life. In this long journey, the thinker and writer in him also found expression in myriad ways. When he gave his consent to be a judge of the Kerala High Court, many of his contemporaries, including friends and well-wishers, were puzzled. Some were even scandalized, given his communist past and considering his incarceration in Kannur jail. To his friends and critics alike, he said, and I quote, "If the tryst with destiny that our nation made long years ago is redeemed, and I have had some patriotic role, some small contribution to make in that behalf, be it as an administrator, promoter of public cause, advocate or judge, viewed in this humanist nationalist perspective, there is no inconsistency Justice Krishna Iyer's thinking was at odds with our constitutional principle. In fact, I would say that his political thought process, it would be a travesty to cite the example of Justice Iyer to justify appointment of people to the higher judiciary having political affiliations which may clearly be at odds with our core constitutional values. It would be a travesty indeed. Justice Krishna Iyer's appointment as a judge to the Supreme Court in 1973 marked a decisive phase not only in his life but also of the Supreme Court and by extension of the judiciary and the nation. Today, I am not going to speak about Iyer as daylight, that his judgments expanded the horizons of constitutional law, emphasizing social justice, human rights, and the dignity of the individual. A firm believer in human justice, he played a pivotal role in interpreting Article 21, thus reinventing the concept of right to life and personal liberty. Known for his eloquent and compassionate style of writing with full-bodied prose, Justice Iyer often blended law with moral philosophy and social conscience. His judicial opinions continue to inspire generations of lawyers, judges, and citizens even after almost 5 decades now. It only reinforces our belief in the transformative power of our Constitution. In 1973, an expert committee on legal aid was constituted, which was headed by Justice Iyer. It submitted a detailed report on May 27, 1973, which formed the foundation for the National Legal Aid Scheme in India. While he was of a firm opinion that since the judiciary is the guardian of justice, an efficient system of legal aid must necessarily contain judicial presence to instill public confidence in the system. But he was mindful of the fact that judiciary should not be entrusted with the implementation of what was basically a social welfare project, which calls for a tenant of a different kind of legal aid programs. In 1977, another committee was constituted headed by Justice P.N. Bhagwati and Justice Iyer, and they submitted a report titled National Judicial Equal Justice and Social Justice. In that report, Justice Krishna had stated, and I quote, "If the state is to secure a just social order for the welfare of the people, and if legal justice is the root of orderly progress, there can hardly be any doubt that poverty jurisprudence must be developed in our country so that human justice through human law can promote in the people faith in the constitutional orders." This paved the way for insertion of Article 39A in the Constitution, and in turn led to the enactment of the Legal Services Authorities Act 1987, which set up the legal aid system in India as we know it today. Justice Iyer viewed legal aid not as a charity, but as an essential element of the rule of law and social justice. Bail jurisprudence was close to his heart, so much so that he gave the clarion call, "Bail is the rule, jail is the exception." Noticing a retrograde step in the trial courts and many of the high courts, Supreme Court in recent times had to reiterate this principle again and again. In Motilal versus State of MP, Justice Krishna, writing for himself and Justice Desai, held that law at the service of life must respond interpretively to raw realities and make for liberties. Writing for himself and Justices Gupta and Pathak in Mantu Majumdar versus State of Bihar, he declared that imprisonment of a person who is undergoing trial without investigation or filing of charge sheet would be in violation of Article 21. His humane considerations and deep understanding of social realities, particularly that of the marginalized sections of the society, convinced him that capital punishment is barbarous and uncivilized. Further, it is highly debatable whether capital punishment has served as a deterrent. So convinced was he about the brutality and futility of death penalty that in Ediga Annamma's case versus State of Andhra Pradesh, Iyer directed the trial courts to limit death sentences using extenuating factors wherever possible. In his autobiography, Justice Krishna has stated about this. Once after I had stopped the death sentence in Ediga Annamma's case, Chief Justice Iyer wondered whether I had done something unconstitutional. I explained to him that even if the death sentence was technically constitutional, it should be applied only in the rarest of rare cases, a position upheld by a 5-judge bench later in Bachchan Singh. Indeed, Long Scarman, the great judge of Great Britain, after 2 big decisions against death sentence in the Privy Council, wrote a personal letter to me saying that he was deeply moved by my pronouncement on the point. Therefore, it was quite but natural that Justice Iyer's attention would turn to prison reforms. When he had left the Kannur jail, he was traumatized by his experience as an inmate in that jail. And therefore, in one case after the other, he tried to make the prison system as humane as possible. Prem Shankar Shukla, Lingala Vinay Kumar, and Sunil Batra are few of those cases where Justice Iyer's commitment for prison reforms and his concern for human dignity are clearly discernible. Justice Iyer's expanding the interpretation of fundamental rights, particularly Article 22. He articulated that cardinal rights in an organic constitution which makes a man human have a synthesis, reinforcing the interconnectedness between Articles 14, 19 and 21, often referred to as the golden triangle of the Constitution. According to me, this judgment has opened the doors for a host of jurisprudence to flourish: public interest litigation, human rights, environmental law, electoral reforms, to name a few. Friends, let me take a slight digression. Last year, around the same time, Mr. Kailas Satyarthi, the child rights activist, a Nobel laureate, he came and met me in my residence. He said, I am organizing a roundtable conference in the same constitution club to discuss about having a compassion quotient in judicial decision making. Since I knew him from before, I regularly agreed. I think Justice Sikri had also joined that roundtable conference online. When my turn came, I said that the judiciary must introspect. There is no point patting ourselves on the back. Certainly, we have done great, we have traversed the wrong way, and we can certainly be proud of our initiative. But we need to introspect as to whether the judiciary could have done better in some cases or in some situations. Only if there is introspection, there can be course correction. In a recent judgment of Justice Abhay S. Oka and myself, it is Wikimedia Foundation versus ANI Media Pvt Ltd. The bench said that courts, as public and open institutions, must always remain open to public observations debates and criticisms. In fact, courts should welcome debates and constructive criticism. Every important issue needs to be rigorously debated by the people and by the press, even if the issue of debate is sub judice before a court. For the improvement of any system, and that includes the judiciary, introspection is the key. That can happen only if there is a robust debate, even on issues which are before the court. Both the judiciary and the media are the foundational pillars of democracy, which is a basic feature of our constitution. For a liberal democracy to thrive, both must supplement each other. But abusing the judiciary is not criticism. While criticism of judiciary is certainly welcome, abuse of judiciary can't be accepted. In recent times, we have witnessed many unfortunate incidents or situations. I am asking myself, is the judiciary under attack? We must seriously introspect and address this issue. People who have no understanding of how the judiciary functions or how a judge works are making scurrilous comments bordering on abuse against the judiciary. Many of them have a vested interest. Many of my colleagues in the Supreme Court feel that we should ignore all such things. But I strongly disagree. I have my own views. To the detractors, I would like to say, whether you like it or not, judiciary as an arm of the state is here to stay. The Constitution has assigned the task of judicial review upon the judiciary. Judiciary must remain true to the Constitution. The recent incident of a lawyer throwing shoes at the Chief Justice of India is part of such an incident. Throwing shoes at the Chief Justice of India, that too by a lawyer, is an unpardonable crime. It is an assault on the institution itself. In Prashant Bhushan, Supreme Court took up so moto contempt petition. A three-judge bench of the Supreme Court held Mr. Bhushan, a practicing lawyer of the Supreme Court, guilty of criminal contempt for posting a tweet on social media regarding the then Chief Justice of India riding a motorcycle without wearing a mask or a helmet at the time of the lockdown during COVID period. In that context, Supreme Court speaking through Justice Arun Mishra declared, and I quote, "The Indian judiciary is not only one of the pillars on which Indian democracy stands, but is a central pillar. The Indian constitutional democracy stands on the bedrock of rule of law. The trust, faith and confidence of the citizens of the country in the judicial system is sine qua non for existence of rule of law. Any attempt to shake the very foundation of constitutional democracy, reservation on the use of the expression iron hand. According to me, this expression of iron hand smacks of subjugation, and judiciary cannot endorse a concept of subjugation. In Wikimedia, we refer to the profound words of Justice Krishna in S. Murgokar. That was again a sober matter, and held that if the court considers the attack on a judge or judges spurious, offensive, intimidatory, or malicious beyond condonable limits, the strong arm of the law must strike a blow. This is to uphold justice. This is to uphold public interest and public justice. This is what makes Justice Krishna so different from the others. He did not use the word expression irony. He said, the strong arm of the law must strike a blow. And this is to uphold public interest and public justice. Yeah. Friends, towards the end of his life, Justice Krishna had started believing in the theory of rebirth. He started believing in the theory of rebirth. Though I believe in God, I have my own views on rebirth and reincarnations. It is not necessary to spell out those today, it's not the occasion. But the point that I am trying to highlight is that if at all there has to be a rebirth. I had said in Pune at a function organized by the Bar Council of Maharashtra and Goa to felicitate Justice Oka that we need bold and courageous judges. We need a Krishna advocate more than ever before. Thank you very much and God bless.